Hi guys, welcome back to Nairobi Legal. My name is Rogers Gerinji, and in this video we are going to be focusing on agreements, offers and acceptance. Remember, in the first two introductory videos on the law of contract in Kenya, we discussed the elements of a valid contract, and so our focus today will be on offer, which we are going to discuss in detail. Before we go into that discussion, I want us to appreciate that according to Section 2 of the Law of Contract Act of Kenya, English law of contract applies in Kenya. And this is the reason why UK cases are used when we are discussing contract law principles, because those principles form part of Kenyan law. With that brief introduction, the goal of this video is to highlight the most common sources of misunderstandings, so that you can avoid making contracts you never intended or deals that you cannot enforce. So this is the objective of this video, and by the end of this video you should be in a better position. Now, the first element we are going to discuss is an offer. We had an overview of what an offer means in the introductory videos. But as a law of contract student, you should appreciate that every bargain begins with an offer. And you need to remember that the person who makes the offer is called an offerer as far as contract law is concerned. And the person to whom he makes that offer, we call him an offeree. So these terms could be so annoying, but remember, we have to be specific on the terminology we use in the law of contract. And the other thing you need to appreciate is that there are other two key terms that you must remember in all your discussions, and this is intention and definite. So what I mean here is that there are two questions that determine whether a statement is an offer or not. And so the first one is that the offerer's words and actions must indicate the intention that he intends to make a bargain, and the other is that the terms must be reasonably definite. So we're going to discuss this in detail so that you understand why I'm telling you to understand the intention of the offerer and the terms of that offer being reasonably definite. We need also to appreciate that there are certain statements that usually do not amount to offers, and these you can see from your screen. An invitation to a bargain is not an offer. So what I mean here is that if you're involved in a discussion with someone, you're basically inviting them to negotiate. That does not amount to an offer. And as you can see from the example I've given on your screen, if there's an invitation to a bargain between Okello and Mwangi, this may not necessarily amount to an offer. Furthermore to that, you might have received a price quote from a supermarket. You might have seen a price quote for goods online. That does not amount to an offer. So you need to remember that it's a statement that usually does not amount to an offer. And the other thing is that letters of intent do not amount to offers, because parties are actually coming up, or rather considering what they can agree to. But according to certain circumstances, a letter of intent may amount to an offer if actually the language used indicates that parties intend to be bound. Now, the other thing you need to appreciate is that an advert does not amount to an offer. So when you watch an advert on TV, or when you read an advert in a newspaper, and then you go to the store to purchase a particular product that was advertised, the seller is free to reject your offer, because you as the consumer, you make the offer, and the seller has the liberty to reject your offer. But as a contract law student, you need to appreciate that advertisers should be very careful, however, not to be too specific in their ads, because should this happen, some ads do count as offers, as was seen in the case of the Carbolic smoke ball. So you can consider reading this case to appreciate at what extent can an advert amount to an offer. So these are the statements that usually do not amount to an offer. In addition to the previous slide, we need also to understand that auctions do not amount to offers. And so placing up an item for auction is not an offer. but it is just a request to an offer which can be rejected or accepted. And so remember that in the course of this video, we're going to be talking about auctions with a reserve and auctions without a reserve, so that you understand what an offer means in the context of auctions. Now, the other key thing we need to appreciate is that a sale of goods by self-service does not amount to an offer. And so what I mean here is that in a supermarket setup, if it is Quick Mart, prospective buyers make offers by conduct. And here what I mean is that they pick up goods from the shelves, and this offer may be rejected or accepted at the cashier's desk. So this lady is a prospective buyer, and in this case she picks up items from the shelves, and the offer could be rejected or accepted at the cashier's desk. Also remember that this lady, being the offerer, she is free to revoke her offer to buy the goods at any time before reaching the cashier's desk. So all of us have entered supermarkets, and we know that when we enter that supermarket, we become the offerers. So we pick items from the shelves, and remember, this offer that we make could be rejected by the person at the cashier's desk. And also sometimes when we go shopping, when we have bought excess items we don't actually need, we are at liberty to remove some of them. By doing that, we're actually revoking our initial offer as far as those items are concerned. Now, this practical example of shopping actually tells you how much the law works in our daily lives. So remember that a sale of goods by self-service is not an offer, and you have no entitlement when you're in a supermarket to force the cashier to actually accept your offer for the goods that you're trying to buy. Now, at the beginning of the video, we talked about the fact that the terms of an offer must be definite. And so, should the terms of an offer be vague, even if the offeree agrees to the deal, the court will not have enough information to enforce it, and there is no contract. In this particular slide, as you can see, I've given two examples that can show you what a definite offer is and what is not a definite offer. So in the first example, and I'm going to read it in verbatim, if a person says, I offer you a job as a waitress in a bar from October 1st through January 1st, 50 hours per week at 500 per hour, this is a definite offer. This is a tick. You see, everything is specific from the beginning, how much you're going to be paid, how much time, and what period. But in the second example, you can see that this is not a definite offer. So if a person tells you, I offer you a job as a waitress in the bar during the holiday season, we will work out a fair wage once we see how busy things get, and your friend responds, that's fine with me. In this case, this is too vague. It can be enforced. There is no contract in the first place. And the reason why I'm saying it is vague is because you can see that the offer is indefinite and there is no contract. Why am I saying this? In this particular example, you can see that someone is talking about a fair wage. What exactly do they mean by a fair wage? Is it 200? Is it 500? You know, in terms of the wage, no one knows how much it is. When someone also says that for you to work for me during the holiday season, what season do you mean? Is it the Easter season? Is it the Christmas season? So that is so vague. So remember that it is very key for you to have definite terms. And so long as you have vague terms, there is no binding agreement. So enforcing this will be so problematic, and you will be the loser in the process. So the point of emphasis is that the terms of an offer must be definite. As you can see, compare the first example and the second one, you can actually appreciate that the first offer is definite. When it comes to termination of offers, remember that once an offer has been made, it can either be terminated or accepted. And so what I'm trying to emphasize here is that should the offer be accepted and the other elements of a contract in this checklist are fulfilled, then parties enter into a valid contract. Remember, the essence of this video was to focus on the first element of a valid contract, which was an offer, and this is what we've been discussing from the beginning. As far as termination of offers is concerned, As a contract law student, you need to appreciate that there are 4 ways of terminating offers, and you can see this can be through a revocation, a rejection, by the fact that time expires, and operation of the law. Now, for the first way of terminating an offer is revoked when the offerer takes it back before the offeree accepts it. So what I mean here is that if you make an offer to someone and before they actually accept that offer, you take back your offer, then in that case you've terminated that offer. The second point is that if the offeree rejects an offer, the rejection immediately terminates the offer. And what I mean here is that, remember, the offerer makes an offer to the offeree, and if that offeree rejects that offer, in this case there is a termination of the offer. The other thing you can also add to this is that a counter offer is a rejection, meaning that if person A, who is the offerer, makes an offer to person B, who is the offeree, maybe I'm selling this car to you at 2 million, and person B responds by saying, no, I can only afford 1 million. That is a counter offer, meaning that it actually terminates the initial offer that was made by person A. So you need to appreciate how counter offers work. The other thing is that when an offer specifies a time limit for acceptance, that period is actually binding. So if there's a time limit that has been set for that offer, that period is binding, meaning that should that time actually expire, then in that case the offer has been terminated. Now, moving ahead, if it so happens that the offerer dies or becomes mentally incapacitated, what we mean here is that you could actually maybe become insane, or you have a mental illness. In this case, the offer automatically and immediately terminates, and this is what we call termination of an offer by operation of the law. Having had the previous discussions on offers, this is a proof that you've understood what offers mean. And so, if you're able to answer these questions, then you're good to go. Now, in this question, you can see that Patricia and Kamau are both not happy. And for the first case of Patricia, she's an interior designer who actually depends on a catalog that has been sent out by the wholesaler. And this catalog provides that chairs cost 10,000. And based on that catalog, she orders for 80 chairs. But the wholesaler notifies her that actually the price of the chairs has gone up to 15,000. So she's not happy. And what is the legal recourse? In the next question, at an estate auction in Langata held without a reserve, Kamau is high bidder on a classic German car. The seller considers Kamau's bid too low and refuses to sell. Both Patricia and Kamau sue, but only one of them will actually win. Up to this point, you can guess which of the two will actually win and why. Now, to answer the previous two questions, you need to sit back, relax, and think. A contract requires an offer and acceptance. And remember, when the furniture wholesaler sent out its catalog, at this point you need to ask yourself a question. Did it make an offer that Patricia could accept? The answer is obviously no. Remember, we discussed previously in the course of this video that a price quote is generally not an offer. And so, Patricia's order for 80 chairs was the offer, and the company was free to reject it. And in this case, Patricia loses. Remember, we had a whole discussion about statements that do not amount to offers, and we said price quotes do not amount to offers. Ideally, when this price quote is sent out and Patricia receives it, by Patricia actually ordering for the 80 chairs, she's placing an offer to the person who sells the chairs, and that person is at liberty to either reject that offer or accept it. So this is the answer in the first question, and for that matter, Patricia loses. In the second question, Kamau was high bidder. Remember, at some auctions, the high bidder is merely making an offer, but at others, he wins the item. The first question you need to ask yourself, as if you paid attention to the first question, it says that was an auction without a reserve. So you need to ask yourself, what kind of an auction was that? So to answer that question, most auctions are with reserve, meaning that the high bidder is merely making an offer. However, this one was without reserve. As you can see, there was a highlight in blue showing that that auction was without reserve, meaning that no matter the amount of money that Kamau set up, so long as he was high bidder, then in that case he gets the classic German car. I hope you've understood how these things operate. Go back, read the question, interlink them to the answers, and think backwards through the things we've been discussing about. Now, as we come to the end of this video, this is an exam strategy again. These are key cases that you can consider reading. As far as an invitation to treat an offer is concerned, read about this case. You can go ahead to read about, as far as counter offers are concerned, these are the cases. You have a case of Hyde versus Reg. So this is just a simple summary that can also guide you. Remember to know the distinction between an offer and an invitation to treat. And also you need to remember that an offer must be communicated to the other party, and you cannot be deemed to have accepted if you are not aware of a particular offer. Now, to conclude and give you an overview of the entire subject of offers, the first subtopic you will see is that there is a counter offer, which there's also an invitation to treat, and we have a termination of an offer. Under invitation to treat, this is where we talk about auctions. Remember, auctions are not offers, but are simply an invitation to treat. When you go to buy goods by self-service in a supermarket, that is an invitation to treat. These are the examples here. When it comes to a counter offer, this cancels the initial offer. And as far as termination of offers are concerned, offers can be accepted. Someone can refuse the offer. There can be a counter offer that actually terminates the initial offer. And if there's a certain time limit that has been specified for an offer, should the time lapse, then the offer terminates, and even death of the offerer terminates the offer. So again, this is an overview and a summary of the entire topic on offers. And in the next video, we're going to be talking about acceptance. Please remember to subscribe so that you can keep on enjoying the content I provide. Thank you so much.